Hi, everybody. Welcome. We've got people still rolling in, but I think we should get started. We've got a lot of material to cover. Today, we will be discussing Employee Organizing 101, what employers need to know before, during, and after employees organize. Um, Before we jump into the materials today, I'm Sarah Nash. I am a partner at PilieroMazza in our labor and employment group. I have a prior life in labor law, which means that I've worked with a lot of labor issues. I've worked with labor unions, have a long history of sort of navigating the nuanced pieces that we'll walk through today. Spoiler alert, a lot of these obligations apply regardless of whether or not you have an organized workforce on site. And so this, even if you're joining us and you don't have unionized labor, it's still very useful tips that we're going to go through. And I'm joined by my lovely colleague, Georgie Kokanis. Why don't you tell us a little bit about yourself, Georgie?
Hi, everyone. My name is Georgie. I am an associate here at PilieroMazza. I work alongside Sarah a lot on a lot of these labor issues. I don't have quite as extensive of a history with the labor law side of things, but I've been working on it a lot since starting here at PilieroMazza.
It's true. We've had a lot of labor issues come up this year. Something's in the water. Quick just update about we're PilieroMazza, full service law firm. We have a number of practice groups, including a government contracts group, labor and employment, where Georgie and I sit, litigation and dispute resolutions, business and transactions, construction, the list goes on. This is also a good opportunity to just give our lawyer plug a little disclaimer that what we are describing today is not legal advice. It is not specific to the nuances of what you and your business might be dealing with. To the extent that you would like to discuss those nuanced issues, please feel free to reach out to Georgie and I separately. Okay, let's get into some of the meat of what we're going to go over today. Again, we're going to be talking about sort of the framework of employee organizing, the before, the during, the after, and what you need to know as responsible employers. Eventually, I think our goal is also to provide a labor law for government contractors specifically, sort of going out over some of the nuances of, in particular, the Service Contract Act and those obligations, because there are some unique ways that those two laws play together. But today, we're not going to be focused on the SCA, more so just general labor obligations that employers have. We're going to go over a little bit of the defining framework, which is the National Labor Relations Act, or the NLRA for short. That is a law that deals with sort of how employees organize, what employers' obligations are to their workforce. And so we'll go some of those kind of legal frameworks. Discussing also employee rights under Section 7 and 8 of the Act. Those are the meaty pieces of the Act that pretty much define every type of relationship that you have with your workforce. And we'll go a little bit over what's referred to as protected concerted activity. That can pop up, again, regardless of whether you have union employees or not. Some very topical issues come up for government contractors in particular, so we'll go over that a little bit. Then we'll go over the organizing process generally. There are a number of stages that you go through in the life cycle of an organizing campaign. And with that comes some additional legal liability, some do's and do nots that we're going to want to focus on to make sure that you are not stepping into it with a contentious union. Just stay on the right side of the law. And we'll go over a little bit of like common mistakes that employers make and how to avoid those mistakes. Then lastly, fun part of the process, assuming that a union is in fact elected as your employee's collective bargaining agent, there are additional obligations that come up. We'll go over a little bit about what that looks like if you do find yourself at the end of a sort of employees having voted yes to a union. That is it for our overview. We've got some learning objectives as well. Before I jump into those, this is eligible for HRCI credit. We will be providing a code at the end of this hour-long session. I'll also mention that I think we've got a good number here to field questions. So if you guys have questions as you're listening along, or you want some additional details on something, feel free to put it in the questions chat Georgie and I will do our best to get to it. If for some reason we're not able to during the presentation, we'll try and reach out to you separately via email. Okay, so at the end of today, hopefully everyone who's following along should know a few key things. One of those learning objectives is going to be understanding employees' right to organize under the NLRA and what you specifically as an employer can and can't do. It's going to help you identify protected concerted activity. That is activity that companies may not discriminate against or retaliate against. And so that's where we often find companies that are not maybe unionized, but then having to deal with the NLRA. That's where it comes up most frequently. Protected concerted activity. We'll go over what that is and how to make sure that you've got good safeguards in place so that you don't walk yourself into an unfair labor practice. We will also identify what is lawful or unlawful for employers, during organizing campaigns. There are some obligations that aren't necessarily intuitive. So I'll go over some of those rules. Again, the do's and the do nots. Also help you understand your obligations following a union certification. There have been some changes in board law over the last couple of years that can really make it difficult for employers. So we'll go over some of those obligations. And then lastly, as always, just avoiding some pitfalls and describing some best practices along the way.
Okay, so we are going to start off with what exactly the National Labor Relations Act is. And you've probably heard of it if you are at all involved in labor relations, but in 1935, it was enacted to address the imbalance of bargaining power between employees and employers. So it was mostly aimed at providing employees with the option to seek better working conditions and representation without fear of retaliation by their employer. So it governs labor relations for most private sector employers, but not every single industry. For example, rail and air carriers are excluded from the coverage of the NLRA. It also does not apply to most public sector employees, so government employees are not covered by the NLRA. And the governing body who enforces the NLRA is the National Labor Relations Board. This is separate from the Department of Labor. So if we'll touch on this a little bit later, but if an unfair labor practice arises and the employer has to respond, they will be responding to the NLRB instead of the DOL or another agency. So what does the NLRA do? The NLRA protects employees' rights to organize, form, and join unions, engage in protected concerted activity, which Sarah will talk about in a bit more detail soon, bargain collectively, whether that is with coworkers or online, which we will also touch on shortly. And then it also protects their right to refrain from union activities. So it is ultimately up to them if they want to join or refrain from union activities. And NLRA protects their rights to do either. The NLRA also defines and prohibits certain unfair labor practices. So it provides guidance on what employers cannot do or should avoid doing. For example, you cannot retaliate against someone for engaging in protected concerted activity. It also establishes the framework for collective bargaining between employers and unions. So this will also come in at the end of this webinar when we talk about what happens after the union is elected and what exactly employers and unions have to do when they now have to interact with each other. So Section 7 of the NLRA protects employees' rights to organize, form, join, or assist unions. It also protects employees' rights to bargain collectively for changes in wages, working conditions, and many other terms and conditions of employment, such as benefits, for example, hours that they're working, etc. And as I mentioned, again, they are permitted to engage in protected concerted activities or refrain from these activities. Sarah also mentioned this in the introduction, but the NLRA applies to both unionized and non-unionized workplaces. So regardless of whether a union is involved, employees have the right to communicate with their coworkers or the public about wages, for example. So if they wanted to talk about the current wage rate that they are set at with their coworkers, even if they're not unionized, you cannot interfere with their right to do so. Sarah?
Okay, so Georgie mentioned I'm going to talk a little bit about protected concerted activity. Before I do that, just to provide some additional context to these obligations, I think part of the problem with the National Labor Relations Act is it gives a lot of benefit to employees' right to discuss their terms and conditions of employment. And that can be difficult when you're dealing with customers in any industry. Regardless of whether it's government contracting, or maybe you're a staffing agency, or maybe you are, I don't know, a janitorial service providing cleaning services to apartment buildings. There is generally this extended protection that gives employees this right to discuss, as Georgie mentioned, wages, grievances, frustrations, and they're allowed to discuss these issues not just amongst themselves, not just with you, their employer, but with third parties as well. And that's where there's this tension often between how do you ensure that you've given employees the right to engage in that protected activity without alienating customers, without frustrating customers, without losing your business. And that is a tension that we see often in a lot of NLRA disputes. A couple of things to remember as you're sort of evaluating this. And I mean, I can go over some best practices, sort of like in your handbooks, how you describe employee conduct and expectations. There are some tricky lines that I would not include in the handbook. For example, you don't want to tell employees you're not allowed to discuss your wages among each other. You're not allowed to disclose your wages to one another. But generally, in order for something to be protected, it needs to be what's referred to as concerted activity. Concerted, generally, just thinking about the meaning of that word, means you're working together. You are working with more than just one individual, so two or more employees acting together regarding terms and conditions of employment. Generally, the idea is that it's towards some ultimate goal. Maybe the goal is to improve your working conditions, to work fewer hours, to be able to, one we've seen particularly frequently is to be able to continue to work remotely. And so it's important to remember, just like you've got protected classes under Title VII, you can't discriminate on the basis of race, you can't discriminate on the basis of religion or national origin or gender. Similarly, you cannot discriminate against employees or retaliate against employees for engaging in protected concerted activity. So one of the questions that Georgie and I always ask clients when they reach out, whether maybe about a termination decision, is, has this individual recently engaged in any protected concerted activity that might make a termination maybe more high risk? We also might ask questions about whether they've engaged in any whistleblower activity. So there are certain actions that employees can take that can give them some kind of a protected status. Everybody's employed at will, unless you're represented by a union in some cases. Everybody's employed at will, which means you can terminate for any reason with or without cause, as long as it's not for a prohibited reason by law. So one of those prohibited reasons would be retaliation based on an individual's protected concerted activity. We've got a list here of common types of disputes that come up. Maybe employees are discussing their wages. Maybe they're going to the government to complain about scheduling. Maybe they are circulating petitions perhaps they're using government email addresses. All of those are closely scrutinized by the NLRB. So it's important whenever you are issuing discipline, whether it be a warning or a formal termination, you want to make sure that you are not putting into the middle of that this protected concerted activity. What's employees' remedy if they are to be discriminated against based on protected concerted activity? They have a right under the NLRA to go file an unfair labor practice or a ULP. And then the board will investigate and has the ability to reinstate them, issue back wages, and issue a number of kind of punitive penalties against the company that can be unpleasant. So you want to avoid that. I do want to iterate that it's important to have some relation to group action. Generally, someone just complaining, well, I want what I want and I want it now in a bubble is not going to be protected activity. It needs to be engaging the rest of the workforce. There are some caveats there. Some board precedent basically says if you're talking about wages, it's expected that it's concerted. So there's some gray area around that definition. Let me just see. Oh no, I've just heard that my audio is not great. Let me try getting a little bit closer to the speaker on my laptop. Thanks for letting me know. And apologies if that was a little bit shaky on everyone's end. I think we can go to the next section now when it talks about what's not protected, because there are some limitations to where protected concerted activity will stop being protected. Some things are just no-go. So if an employee engages in violence or threats in violence, that's not going to be protected by the act. Generally, cursing is also frowned upon, but it kind of depends on the facts and circumstances. Someone who is working at a work site where there's a lot of swearing might not be held to the same standard as a work site where there's absolutely no swearing whatsoever. Harassment is not prohibited or is not permitted. Gross insubordination, for example, an employee should be expected to perform their job duties to the extent that they don't risk some sort of personal safety. So you can still expect employees to do their job. Strikes about a union's jurisdiction over a type of work are not prohibited. There's a number of these other outside the box obligations, but barring anything on this list, generally employees do have quite a bit of leverage when it comes to discussing their terms and conditions of employment, whether again it's with themselves or with other third parties.
I also did want to mention, Sarah, you mentioned handbooks, and we always take a close look to make sure protected concerted activity, everything is going correct under the NLRA and people's handbooks. I think another policy we look closely at is the social media policy, because a lot of times people won't think that what people post on social media could possibly be protected under the NLRA, but it can. So we always take a close look and add some language to those policies if we think it might be necessary.
That's a great point, Georgie. Am I doing this one?
Yes.
Okay. So Section 8 is the other side of sort of the NLRA. It focuses on employers' responsibilities. And it's mostly a list of what you cannot do. For example, you're not permitted to interfere with employees who are exercising their Section 7 rights. That's that right to, choose to be or not be in a union, the right to discuss terms and conditions of employment, those obligations that are protected under the Act. It also prohibits retaliation or discrimination against employees for engaging in that protected activity. This often comes up with when there is a union organizing campaign. Sometimes the individuals who feel most strongly about the union are also individuals who tend to rub certain coworkers the wrong way. Maybe they're overly vocal about their feelings. And so they might not always engage in their advocacy techniques in the most professional way. However, because of the heightened scrutiny that the NLRA provides for protected activity, it's important that you treat those maybe disciplinary actions as high-risk disciplinary actions. So you want to be very conscientious of the fact that you are not disciplining an employee because of the fact that they're discussing these issues. Maybe you can focus on them completing their job duties, performing professionally, following instruction. There are just some best practices for how you navigate those sort of tricky, nuanced situations. Section 8 also prohibits employers from discriminating based on union membership. Sometimes this comes up maybe while you're engaged in hiring for a new contract. It's important that when you do decide who to hire, you are not factoring in whether that individual is part of a union or not. Very important that you do not discriminate, and you should not actually even be asking if the individual is a member of the union. It should not factor into your decision. This sometimes comes up in the Service Contract Act world, just when it comes to figuring out what the incumbent workforce looks like and whether you'd like to bring on those folks or hire new folks because the non-displacement rules are no longer in place. Section 8 also prohibits employers from interfering with, or on the flip side, unlawfully supporting a labor organization. The idea behind that is that employees should have the right to choose. So whether they choose that they would like a union or they choose that they would not like a union, that decision should be made amongst themselves and not amongst the company representatives. We'll go over that a little bit more in depth when we talk about what to do when there is an organizing campaign and how you want to position yourself such that you are not unlawfully interfering with employees' right to choose. Lastly, Section 8 also prohibits refusing to bargain collectively with the union, assuming that employees have identified that they would like to be represented by a collective bargaining agent. At that point, you have an obligation to negotiate with that union in good faith. And again, if you violate any of these obligations, employees and unions have the right to file an unfair labor practice with the National Labor Relations Board. Just flagging, this is not exclusively a right that unions and employees have against employers. Employees can file ULPs against unions. Companies can file ULPs against unions. In that respect, there is sort of equal opportunity to file your grievances with the NLRA, though they do often sort of have a slight bias in favor of employees.
So that was all the background on the NLRA, and now we're going to talk about the actual union organizing process. So as we mentioned at the beginning, we like to think of the organizing process in stages. So we'll go through each of these one by one, but the first one would be employee organizing activity, then authorization cards and showing of interest of the union. Then would be the petition for the NLRB election and the NLRB election, where the employees will actually vote on whether or not they want the union to be their representative. And then lastly, union certification if the majority of the employees who cast a vote yes for the union. So stage one is the employee organizing activity. So organizing often begins with employees expressing interest in union representation. So activities might include employees discussing workplace concerns in terms of employment amongst each other, working with union organizers more explicitly, formation of an employee organizing committee. So you can tell there's clear action that they are trying to organize and be represented by a union and not just go through the employer for everything. Sometimes you'll actually see distribution of union materials. So this is flyers, handbills, authorization cards, which Sarah will discuss a little further in a minute or two. So when you are recognizing that employees are beginning to show signs of organizing activity, you want to make sure that you maintain lawful and consistent workplace practices. For example, you don't want to suddenly retaliate against employees because you believe that they want to be represented by a union. That is their right under Section 7, as we just discussed. And you don't want to interfere with their rights to be represented by a union or organize.
I'll also mention here, Georgie, how important it is to make sure that your managers are also familiar with these obligations. I'd say it's even worth a separate training. If you do catch wind of an organizing campaign, make sure that you're training your managers and how to respond. Make sure that you're maybe circulating recommended responses or draft responses that they could provide, because it is pretty easy, as George is going to go over on the next slide, to, inadvertently violate some of these obligations. Georgie, do you mind if I just respond to one question that came in? It's this question of the types of violations a union could have or could perform that would qualify as a ULP. It's not as expansive as employers list as you might imagine. But for example, coercing employees, maybe threatening them that if they don't vote for the union, that believe it or not, there is a history here of certain unscrupulous unions, threatening violence if employees don't vote the right way. They also have a duty of fair representation to employees that comes up fairly frequently, to the extent that the union is not fulfilling their obligations of being the collective bargaining representative. Employees have the right to go and complain that they are not being fairly represented. And that's just a few examples of tacks that unions have historically taken that have earned a ULP from the board.
Also, not only the employer has a duty to bargain in good faith, but the union also has to bargain in good faith with the employer. So that's a two-way street.
Mm-hmm.
Okay, so along with stage 1, and actually relevant for all of the rest of the stages, as we'll discuss, there are certain actions that we advise clients that they can do and that they cannot do during an organizing campaign. So some of the things that you can do is you can communicate the company's opposition to unionization. You can say, we don't think this is in the best interest, but you can't interfere with their right to vote how they wish to. You can also communicate employees' rights. They have the right to refrain from participating in union activities or the right to engage, as we discussed under Section 7 of the NLRA. Along with that, they can vote for or against union representation, and you do not want to interfere with that whatsoever. They also have the right to discuss workplace issues and union-related topics during non-work time and in non-work areas. Another thing that we advise clients to do is to communicate to the employees the benefits that they currently enjoy when the union is not yet involved. So an example of this would be employees can come to the company directly for issues relating to their terms and conditions of employment. So for example, if they want higher wages, they don't have to go through the union to get those higher, or to talk about obtaining higher wages. They can talk directly to you. But if the union becomes the collective bargaining agent and representative, that is a different story. So along with that, individual employee benefits may be compromised for benefits of the entire unit. Along with that, we also advise that clients communicate the downsides of union membership. And the example I just mentioned of employees having to go through the union for individual concerns is one of those drawbacks, which employees don't necessarily think about. There also may be payment of dues and initiation fees, so it may actually be more costly to them in the long run if they join the union. And then again, along with that, depending on the union, also depending on the state in which the employees are located, there may be fines and assessments that are imposed by the union on the employees. Lastly, we strongly advise that employers inform the employees that the union cannot guarantee anything during this process. They might try to tell employees that if they vote yes for the union, they are guaranteed to have higher wages. That is not the case. They may have higher wages, but everything will be negotiated in the collective bargaining phase. So they can't actually promise any better benefits to the employees.
Absolutely true. And that comes up on the next slide that we're going to talk about authorization cards as well. Oh, maybe I jumped ahead.
One more slide.
Sorry, slide. Sorry.
Along with that, on the other side of things, we advise not to do certain things during the organizing campaign. So as I alluded to, you do not want to threaten or coerce employees into voting a particular way. You cannot say that they will be terminated if they vote yes for the union. That is surely going to make a ULP appear. You cannot spy on or create the impression of monitoring organizing efforts. That also might indicate to the employees that they are being treated differently because of union activity. Similar to how the union can't promise anything to the employees, employers should also not make promises that the company will improve certain working conditions if they vote in a certain way. Again, all terms and conditions of employment are going to be, well, all mandatory terms and conditions of employment will be negotiated through the collective bargaining process with the union. So making any promises during this time is frowned upon. And lastly, you should not retaliate against employees for voicing a pro-union opinion or participating in any way in the election process. So again, employees have the right to engage in the union organizing process or refrain. It is entirely up to them, and you cannot retaliate for their choice to or to not do so. Back to you, Sarah.
Thanks, Georgie. I was just going to add that when it comes to authorization cards, there's a lot of misinformation out there. And that's generally, I feel like the process for an NLRA election is not very straightforward. It has a lot of moving pieces, a lot of dates, a lot of timelines that need to be hit. And it's not always easy, especially for workers who maybe aren't used to, maybe English isn't their first language, maybe they're not as versed in sort of navigating those legal obligations. So this is always a good opportunity to educate employees and workers about the process, make sure that they know that if they do not want a union, it's really important that they vote in the election, because the ultimate count is based on the number of people who submit a ballot. It's not really based on whether that's the majority overall. So there are some really easy pieces of information that companies can provide, assuming that you don't want a union, or even if you do want a union, that just makes sure for a better, free, and fair election. Stage 2 here has to do with authorization cards and generally a showing of interest. Basically, in order for a union to be presumed to be employees' collective bargaining agent, there needs to be a majority of individuals who have expressed an interest in their representation. And there's a few ways to show this interest. Most common is to for the union to ask employees to sign authorization cards. Generally, an authorization card is something that you need to either show the board that you have a showing of interest enough such that you are entitled to an election, or on the flip side, to show a company, an employer, that they should maybe consider voluntarily recognizing the union because the employees have showed a majority are interested in that representation. So authorization cards are basically an easy way to show that that interest is there. It's not the only way. You can have everyone crowd into a room and say, yes, I want a union. You could have some type of other polling system. The law does not specify how that showing of interest needs to occur, but this is sort of the easiest way to do it. there's a lot of confusion around authorization cards. Sometimes unions might say, oh, don't worry about it. This is just to get more information about the union. So I like to make sure that employees have actually read that card, understand what it means before talking to maybe a client about voluntary recognition. If you don't generally have a majority of employees who have expressed an interest in the union, you don't even have the option to voluntarily recognize. At that point, if the union has, it's 30%. If they have 30% of the workforce that's showing an interest in the union, then they can take that to the NLRB and say, hey, we'd like to have an election. Generally, all the employee needs to do is just sign on the dotted line saying, yeah, I'm interested in a union. No authorization cards are the same. They can all vary depending on the union. It's important that employees read that. There is a little bit of tension behind this idea of the union being able to show interest and still the employer's obligation not to retaliate based on union interest. So if you do have an opportunity to see the names on that card, it's just really important that you not hold a grudge or treat employees who have expressed an interest in the union as maybe under more scrutiny than you might other members of the workforce. Importantly, signing an authorization card does not automatically create a bargaining relationship. You need to go through an extra step, whether that step is going to an election or voluntarily recognizing employees. And we'll also talk about another step along the way where employees, where a union does ask to be voluntarily recognized. There's recent board law that basically puts some additional obligations on the company. Really important you check those boxes, or surprise, you could end up with a union without an election. So there's some pretty important rules that have just cropped up around that. Okay, petitioning for an election. So if a union has sufficient support, again, it's that 30% showing of interest, it can go to the board and petition for what's called an RC petition, a representation election. That's basically what it sounds like. It's giving the employees an opportunity to vote on whether or not they would like to have a union as their collective bargaining representative. Under that recent case law I just mentioned in 2023, a decision from the board basically held that where a union requests recognition based on the fact that they represent a majority of employees, the employer has to do one of two things. They either voluntarily recognize the bargaining unit, or they have to promptly file an RM petition with the board, which is basically the company's way of seeking an election. Promptly generally means within 2 weeks. The consequence of missing this obligation could be that the board says, great, you missed it, so now you still have to negotiate with the union without even having an election. There's a presumption that has been imposed at that point that the employee should be allowed to have the union. So it's really important that you follow those timelines. I find that often unions will go ahead and file for an election petition anyway, but this is sort of a potential gotcha moment. If any union is talking to you about voluntary recognition, you want to make sure that you either get in touch with counsel or collaborate internally and make sure that you reach out to the board for an RM petition, assuming you're not going to voluntarily recognize employees. The petition itself will start the NLRB representation process. The union has an obligation to file the petition with the NLRB, provide a copy to the company, and then pretty quickly, because there are regulations in place under the statute that require a prompt process, pretty quickly you'll get outreach from the board saying, basically, do you dispute the scope of the bargaining unit? That means the employees that the union is seeking to represent, do you agree that those are properly within the scope of the unit? Questions that come up might be, oh, well, this individual is a supervisor. Spoiler alert, supervisors cannot be covered under the NLRA. They are exempt. So there are different rules that apply to supervisors. So they should not be included in a bargaining unit unless basically the company and the union agree to that exception outside of the scope of the act. Other questions that might come up might be whether there are joint employer issues. Maybe the union's trying to have one unit that involves multiple employers, employees? Those are questions that really need to be issued before you start issuing ballots to individuals. If there's disagreement between the union and the company on what the scope of the unit should be, whether the election should be in person or via mail-in ballots, or some other terms like when the timing is, then you might have to go to a hearing. Often, though, you're able to fix those discrepancies, come together on an agreement for election. If you can do that, you don't have to go to a hearing to discuss those sort of outlying issues, and the board will issue a basically ballots to your workforce and allow them the opportunity to vote. And again, that opportunity is either in person, usually at the work site, or via mail, which parties generally have the ability to negotiate over which one should apply. And I think that's it for the petition.
Along with stage 3, also, I guess, part of stage 4 too, when an election is going to take place, the NLRB will contact the employer directly and send kind of a long document basically saying what its obligations are. And one of those obligations is to provide employee information, which includes employee address, what their work hours are, their phone number, all of their contact information. So that's another action item that falls to the employer in the midst of the process. So you will just want to be ensuring that you are complying with all of the obligations along the way. But if an election is held, the NLRB oversees the entire process, and they are conducted by a secret ballot. This kind of is a safeguard so employers are not retaliating against employees, whether they vote yes or no for the union. It also provides employees with they feel better about submitting their vote however they want to. So the ballot will really just have one question on it, and it's just asking, do you wish to be represented by the union? And it's a yes or no. And the employees will just check one box. They have some instructions which will be sent to them, or if the election is in person, the instructions will be made available to them, but they have to put the envelope a certain way, sign it a certain way, otherwise their vote might get thrown out. But that ultimately is on the employees to follow the instructions rather than an employer obligation. And again, the NLRB ensures employees have the opportunity to make a free and informed choice on whether they want to vote yes or no for the union. So the outcome of the election, we mentioned this previously, but it matters the majority of the votes actually cast. So even if the bargaining unit is made up of 40 people, if only 20 people vote, the majority of those 20 is whether the union will become the representative of the employees. So it has to be a majority, as I said, so it cannot be 50-50 because then that goes in the employer's favor. But during the process, as I mentioned, some ballots will be thrown out. So there might be objections during the review of the ballots by either the employer or the union on whether certain ballots should be counted. For example, if an employee didn't sign it, usually the ballot won't be counted, but someone might say, I object, and that goes to a process after the election. But that only really comes up if there's an issue with the count and the ballots that are not counted would actually make a difference to the overall vote. So if the employer or the union wins in a clear majority, this won't be an issue, but it might come up. And so if the union does get the majority of support among the votes actually cast, it will move toward union certification. And if the union does not receive majority support, the organizing effort usually ends unless another petition is filed, which we have seen before, but usually that will just be it from that union. And the employer will remain the representative of the employees. So next up is the last stage of the organizing process, which is the union certification. So as I said, if the union wins the election, the NLRB certifies the union as the employee's exclusive bargaining representative. This means that now, moving forward, the union represents all employees in the bargaining unit instead of the employer. So the employer must recognize the union. They can't just move forward as if the entire process did not just happen. So the parties will move into the collective bargaining process. As I mentioned, that involves negotiations on all mandatory terms and conditions of employment, but we'll get into that in a little more detail soon.
Yeah, so going over, I know, and I apologize, this is a lot of information. I appreciate that it's a lot of information. I think the point of this is really just give you enough to know, what you don't know, where you might want to pay special attention to the rules and requirements, or just put on folks' radar if there is a scent of organizing, there are some pretty important steps that you need to be taking. One question we received is if there's a good training out there for managers. There probably is. I have not seen one. I know that we spend quite a bit of time just having conversations with clients about what those steps look like, making sure that we circulate good instructions. But, labor law is a very old and very busy practice. I'm sure there's some good trainings out there, and I'm happy to take a closer look, see if I can find any that might be a good option if folks are in that circumstance. Again, you don't want to ignore any early signs of organizing. It's easy to just look the other way, try to act like, oh, I don't know what's going on. You don't want to do that. You want to get ahead of it, mostly so that you can advise your managers on best practices, maybe get ahead of some questions. Again, misinformation is common. So if you can make sure that you're providing employees with accurate information that makes sure they really understand the circumstances of what's going on, that might be more likely to get a no vote on the union. You want to make sure that no one's getting disciplined for engaging in that concerted protected activity, whether it's because they're encouraging employees to think about organizing, or whether it's because they're just complaining about standard terms and conditions of employment, either to themselves, again, or to your customers. You want to make sure that you're not making inconsistent policy or disciplinary decisions. Is a good plug in general for just labor and employment best practices. Make sure that you're engaging in progressive discipline, that you have comparators. That means that similar individuals who maybe haven't engaged in protected activity are treated consistently, that you're following your policies and procedures when it comes to policy violations or code of conduct violations. As long as you're doing all that stuff on the back end, you're in a much better position if you do need to discipline someone who happens to be wound up in the union organizing campaign. We haven't talked about access rights. That is a long historic journey of labor law cases, but there could also be circumstances where union representatives are entitled to be on site at your work site. A little bit harder if it's government property. So you just want to make sure that you're conscientious of those limitations on what you can and can't prohibit those union representatives. Again, best practices: train your supervisors and managers, keep communications open with employees, make sure that you are giving them accurate information and not otherwise chilling. It's a common term, chilling their right to engage in free speech. You don't want them to feel like they're not allowed to engage in those topics. And then never a bad idea, if things do get a little bit hairy or going in a certain direction, reach out to counsel before you maybe take disciplinary action. One good example of an easy way to mess up is captive audience. And I don't know, Georgie, if we discussed this elsewhere in the slides, but captive audiences are basically this idea where you force or you require employees to attend a meeting discussing the union organizing. That is basically prohibited under recent case law. So as a company, you can allow employees to voluntarily attend these type of meetings, but you should not be requiring it. And furthermore, when you do have a meeting, you should not be keeping tally of who attends. So there are some things that seem innocuous that could actually threaten to be a violation of the NLRA. And I will say that unfortunately, there's not a lot of rhyme or reason. The board has a really frustrating penchant to go back and forth depending on the administration. So it's sort of like watching a tennis ball go back in class across the net. It just flip flops every 4 years or 5 years or however long it takes for a different administration to get their majority in the board. And so it kind of depends on what the state of the law is just on the day that you're looking at it. And I think we're going to get into after the union is elected now. Yes. Okay. I got one right. So we've talked a lot about the steps leading up to an organizing campaign. And now we're going to spend the last 10 minutes or so talking about what happens if the union is actually elected, because believe it or not, there's a whole additional list of obligations. This is not a deep dive into the collective bargaining process. It's just intended to sort of give you enough to know that you might want someone who's familiar with labor negotiations. Doesn't have to be an attorney. A lot of unions don't use attorneys for their negotiations, but I think it does have to be someone who's familiar with how this process works. Often as attorneys, we'll either be on the other side of a negotiating table or we'll be in the background saying, yeah, like, hey, what if you paint it like this? The union might go for that. So there are some different ways that you can structure your bargaining team. But once a union has been certified or once you voluntarily recognize it, it becomes the employee's exclusive bargaining representative. That means that's their union. You can't negotiate with another union on the terms and conditions. You have an obligation to negotiate with that particular union. And that negotiation has to be in good faith over, as Georgie mentioned, mandatory topics with the union. Generally, those topics include, wages, benefits, vacation, pension sometimes. So you got to be really careful when you agree to a pension package. I'll also add that this is not always following a union certification. Sometimes you this comes up a lot in government contracting. You might be a successor contractor who inherits a bargaining relationship. That obligation kicks in. There are some rules about negotiating with that union, but you do not have an obligation to assume the prior contractor's CBA. There's a lot of kind of misinformation out there about whether or not you have to sign on to those exact terms. You do not, but if you do hire a majority of the workforce, you do have an obligation to still negotiate. You have an obligation to provide information to the union. Information requests are pretty common. Anything that has to do with the bargaining unit. Maybe it's their current salaries or wages. It's the type of benefits they take. Maybe it's their disciplinary files. Anything that touches on those bargaining unit rights, the union is entitled to. And it's important that you provide that promptly, or at least in a timely fashion, because if not, guess what? The union could file a ULP. It's also important during this initial bargaining period that you not engage in what's referred to as unilateral changes. That's basically changes that the company makes on their own without providing notice to the union or an opportunity to bargain. It's really important that you are keeping the status quo while you're negotiating on those subjects of bargaining. You have an obligation to meet at reasonable times. You don't have to meet wherever the union says. You can say, no, I want to do remote sessions. Maybe the union will go for it. Maybe they won't. That's all part of the negotiating process. And then you basically agree to meet with the union until you get a CBA in place. And that CBA will determine most of the terms and conditions of your workforce. Not all of them. Some stuff is still addressed in the handbook, but certainly your wages, your benefits, often staffing hours, what it takes to have a layoff in some circumstances. All of that stuff is stuff that you're going to be negotiating with the union. Sometimes the union will have an initial proposal that they'll submit, makes it a little bit easier. Although I've seen it go both ways. They might just say, what do you got? And that first contract is usually a lot harder to negotiate than any successor contracts, just because you're building it from scratch. And it's going to take a little bit more time. But the idea is that once you've got the basic framework down, at the end of that CBA, when you negotiate a follow-on CBA, it should not be nearly as time consuming as the hope. And I think that's it in terms of after, like, kind of starting the bargaining process. Okay, really quickly, because I appreciate that we're coming up on the last 5 minutes. What must employers bargain over? Those mandatory subjects of bargaining. These are things that you can't say, no, we're not going to talk about that. Not going to deal with it. You're not allowed to do that with those things because, again, what happens? ULP. Issues that directly impact the employee's terms and conditions of employment, wages, benefits, working conditions, disciplinary procedures. Often you'll see that just cause language for unionized employees basically provides that the employee can only be terminated or disciplined for just cause. That's one of the primary benefits, I'd say, in addition to wages, that unions are really excited about. There's usually a grievance process that's worked in through there. Certain types of things are not mandatory, which means you can say, no, we're not going to bargain over that, but the list is small. Examples might be subcontracting with for the services or relocation of the work. And then if it's not addressed in the CBA, often you would have an obligation to go provide notice and opportunity to the union. So if there's something that's really important to you, this is just another way of saying you should probably make sure that it's in the CBA and talk about it with the union. We got one question that I think I can answer pretty quickly. The question is that the unions that they work with frequently request addresses, birth dates, phone numbers, email addresses, and other PII. Do we need to provide all that? What are restrictions on what they can request? Unfortunately, I've looked at this very question because, believe it or not, this comes up quite a lot. Basically, the union's entitled to everything. It's very hard to say that that is outside of the scope of what they're entitled to as a union. Sometimes if you have particularly sensitive information, you can get them to sign a protective order that commits not to share it with others. I've had that successfully. I'd recommend it if you're uncomfortable. They might go for it just for the sake of going along to get along, but it is a very broad protection that they have of their right to information. And that information goes both ways, so you can also ask the union for information. They're obligated to provide it.
Okay, quickly, we'll just talk about the collective bargaining agreement in general. The parties generally will reach an agreement on negotiated terms and enter into the CBA. It depends how long what I'm trying to say is every situation is different. Sometimes this happens rather quickly. Other times the parties take a bit longer and there's a lot more back and forth on certain terms in the agreement on how long it will take between the time the union is elected and when the CBA is put in place. But if an agreement cannot be reached after sufficient good faith efforts, and keep in mind good faith on both the employer and the union's part, the employer can declare impasse. And if that happens, what would happen is the employer could implement the last offer they presented to the union. But then the union could argue that impasse was not actually reached and file a ULP. This is a bit complex for the purposes of this webinar, but
there's a whole set of case law on, impasse. It's really hard to get to impasse. It's very, very hard to get to impasse, but it does happen.
Usually an agreement will be reached, and as I said, it just kind of depends on the situation, how long that will take. But the CBA should establish the duration of the agreement. We often recommend 3 years. We have seen 10-year terms, and we generally would advise against that for the most part. It should also establish the terms and conditions of employment, wages, benefits, policies such as discipline, et cetera, et cetera. It should also establish employer and union responsibilities. It will usually always have arbitration procedures. So if a dispute were to arise, what exactly the employer and the union obligations are to get that dispute resolved eventually. And yeah, the procedures for addressing all of the workplace disputes, all of this should be within the CBA, so it's very clear to everyone involved how to address issues. Okay, and then the ongoing employer obligation. Throughout the bargaining relationship, employers should follow the terms of the CBA. We often see this, especially with the disciplinary procedures. You will want to ensure that you are actually adhering to those. So if progressive discipline is in the CBA, you want to make sure you are following that, because if you go straight to termination in certain instances, another ULP could arise. We just discussed this, but providing relevant information to the union when asked, when required. Make sure you are maintaining communication with the union. If they are reaching out to you, you should make sure you are responding in a timely manner. And again, avoid bypassing the union or making unilateral changes, especially on those mandatory bargaining subjects. Okay, and then we've said this several times, but again, failure to comply with any of these things could result in an unfair labor practice charge against the company.
Great, and that brings us, we are at the conclusion. We did it. Sorry, we're a couple minutes over. Just a reminder that this is a different process. It's not intuitive, it's frustrating, it's tedious, it's annoying, in large part by design. And so important not just to rely on intuition on a lot of these things. Part of the reason we decided to have this webinar is we've been getting a lot of questions about organizing campaigns and how that works with government contractors and what obligations attach. And so we thought it would be helpful maybe as a jumping off point just to touch the surface on some of those obligations. And just generally just keep in mind, important to know the rules, important to engage in good faith. And again, I'm just going to harp on not retaliating against individuals based on protected activity, because we're seeing a lot of that. Georgie, do you have anything to add from this list?
No, but I did want to say we got one last question. Should union staff sign the employer handbook?
Yes, they should. However, you generally will want a different acknowledgement. Most acknowledgements that are out there say you're employed at will. There is a separate acknowledgement that you might want to have your unionized workforce sign that basically acknowledges that they're represented by a union, maybe less emphasis on the at-will employment, given that they have just cause protections. Great. Okay, that's it. I think that we got through most of what we wanted to talk about. The recording should be available. I think we'll circulate that to attendees or anyone who signed up, usually about a day afterwards. So that'll be available. And certainly if you have any other questions, please feel free to reach out to Georgie or me. We really appreciate your time. And if you have suggestions for any webinars you'd like to hear about in the future, please let us know. We are very much doing this, trying to help out clients and other participants and address the questions that you have.
Thank you, everyone.
Bye.